I've just placed we're on, you're live, whether you want to be or not. We're all live and streaming now. Okay. I didn't know if you know this, but all four courts stream what they do all day. And so, which makes for really entertaining television or absolutely boring television. Okay. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both the person who is accused of a crime and the prosecution have the right to a trial, not by one person, but by a jury of 6 impartial persons. We will pick 7 for this jury, okay? And I'll explain that all to you later. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A trial begins with a jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this case, even though you may otherwise be qualified as a juror. The questions may probe deeply into your attitudes, belief, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do not understand it, you should answer truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from service on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there's a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. When we dismiss a juror from this case, it's my understanding that the jurors are staying in the courtroom, and then we're going to take them over because we've got another jury trial going on. So you'll be taken over to answer any questions that those lawyers may have in front of Judge Buchanan. I will now ask you to stand and swear to answer truthfully and honestly all the questions that you will be asked about your qualifications to serve a juror in this case. If you have any religious beliefs against taking an oath, you may affirm that you will answer all questions truthfully, fully, and honestly. So I'll have the whole panel stand. Okay. I'm going to have you raise your right hand or affirm. Okay. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case?
Yes. Yes.
Okay. Is there anybody who said negative in that response? All right. You can have a seat. Thank you. So I'd like to introduce you to members of my staff. So Wendy Holden is my court recorder, and you probably can't see her behind the computer, but she's back there and she's taking down everything we say. All right. And so the microphone, you'll hear me talk to the witnesses as they come on, and I'll tell them the microphone really goes to her ears. So they have to amplify so the jury can hear, and they have to amplify to the back of the courtroom. It doesn't amplify on its own. All right. Megan Slaviak is my court officer, and she not only will be taking care of your needs today, but also once we pick a jury, she'll be taking care of making sure that we have the right breaks, that you all have the right breaks, and that we get you paid for your time, which is probably the most important thing. This is a criminal case involving the accusation or charge of malicious destruction of personal property, $200 or more, but less than $1,000. And I'll fully explain that more later, okay? This charge has been made against the defendant, who is Brandy Hoover. The defendant's lawyer is Joseph Lee. Please introduce yourself, sir.
Thank you, Your Honor. My name is John Lee.
John Lee.
That's okay. I'm an assistant public defender here in Ingham County. I will be representing Miss Brandy Hoover, the defendant in this case today. Pleasure to meet all of you, and thank you so much for being here.
Thank you, Mr. Lee. There's 2 lawyers for the state of Michigan on this case, and I'll have them both introduce themselves for the record.
Thank you, Your Honor.
Hi, everybody. My name is Abby Wilson. I'm an assistant prosecutor with Ingham County. It's my privilege to represent the people of the state of Michigan in this matter, and I'll be assisting Ms. Rizos, who will represent herself in this matter as well. Thank you.
Mr. Sills.
Good morning, I'm Natalie Rizos. I'm a third-year law student, and I am practicing under the Michigan Court Rule 8.120. And thank you all for being here. It's a really important rule. So, no, it's not the best thing to be doing, but your job here is really important. So, thank you all for doing it.
All right, thank you, Mr. Rizos. The witnesses who may be called in this case by the people of the state of Michigan are Officer Jacqueline Lindeman, Cassie, it's Casey. Casey Lynn Wright, and Eilena Carson Wright. Is that right?
Correct, yes.
Did I pronounce that correctly?
Yes.
All right. Does anyone in the jury box or waiting to be, does anybody know any of the lawyers or witnesses in this case?
No.
Perfect. All right. I'll indicate that there was a general no from the panel, and then any specific questions can be raised by the litigants in the matter.
Your Honor, I apologize. Did we include the defense witness that we had discussed in that?
Oh, correct. Thank you, Ms. Wilson. The defense is going to, at this time, anticipates calling Keisha Thompson. Right, Keisha Thompson. Does the voir dire know anybody? And did I pronounce that correctly?
You did.
All right. No.
That's what he said, right?
Did I say Thompson?
Oh.
Keisha Thomas. Okay. Does anybody know Keisha Thomas?
No.
All right. No. Thank you. We anticipate this will go about a day. All right. It's a 1-day trial. If you believe the length of the trial will be really hardship for you, please, is 1 day too long for anyone? No. All right. And you can all involve this in some of your answers to both parties. All right. So some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Does anyone have a sight or hearing problem in the jury panel? No. All right. I noticed that because it's my job to notice that some of you may have strained something or to stand up to give the oath, but that doesn't present a problem with sitting and listening and hearing any witness testimony. I would think we wouldn't go longer than a couple hours, and then we take a break. All right. I have to be reminded to take breaks. So if you need a break, just raise your hand. And this is a criminal case. The paper to use the charge to the defendant that the law enforcement uses and the people of the state of Michigan use is called a complaint. The complaint in this case charges that Brandy Hoover with the crime of malicious destruction of personal property. That is commonly referred to as MDOP. It is the amount in dispute is $200 of destruction of personal property, $200 or more, but less than $1,000. All right. The offense location is indicated at November 18th, 2023 at 601 South Butler, City of Lansing, Ingham County. And it reads in part, and I'll read, Brandy Hoover is alleged to have willfully and maliciously destroyed or injured the window of a 2019 Chevrolet Cruze, the personal property of Cassie Wright, and the amount of destruction or injury was $200, but less than $1,000. Have I accurately surmised the complaint?
Yes.
Yes.
All right. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial, entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of a parts called elements. The prosecution must prove each of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecution has not proved every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair doubt, honest doubt, growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. And you'll probably hear more about that from the parties in the matter, okay? As your name is called, please come forward and I'll take your seat in the jury box. Unfortunately, juror number 1 has to go all the way. That's because we don't have a door on the other side. So that'll be the first seat is the furthest to the left, and then we will pick the 7 additional jurors. So it'll be 7 in all. Please take your seat coming forward, the back row with the closest seat to the back of the courtroom, and filling in across the back row and the front row in the same manner. I will call what's been previously drawn witnesses first, and then we'll go from there. All right. So the first witness, juror number 1, is Shannon Sickles. Ms. Sickles, we're going to have you climb over every chair. Juror number 2 is Lindsay July. Juror number 3 is Maggie Basner. Juror number 4 is Jennifer Ranshaw. Juror number 5 is Mitchell Stevens. Juror number 6 is Christina Daly. Juror number 7 is Kyle Pate. All right, we'll start with some questions. You heard my questions already concerning health and the date and the day of. We'll start questions with the people. Ms. Drizos, would you like to proceed with voir dire?
Yes, Your Honor.
Okay, you may proceed.
Thank you. Morning again. I'm going to cover 3 overarching topics with y'all today to learn a little bit more about who you are. Those topics are going to be first who you are. The second is going to be witness credibility, and the third would be your role in sitting on this jury. Starting with each of you here today. There may be, as the judge had covered before, an instance or personal experience in your life that may make you fit to sit on one jury, but perhaps not another. It may be something close to home, something related to a family member or a friend who's close to you that just wouldn't make you the most impartial person to sit on this jury. And that's our goal here today, is to create a jury who can fairly listen to the facts and go back and deliberate on those facts, only those facts alone. So there's no right or wrong answer to any of these questions. I truly just want you to answer honestly, so that way we can make sure that the 7 people sitting at the end of this process are the 7 most impartial people that we can have here. Let me grab. So sorry. Lindsay, since you are a ticket taker, can you kind of explain what that role encompasses?
I'm just the MSU football games.
Okay.
The home football game. So just when someone comes in, you gotta scan the ticket.
Okay, awesome. And then has anyone on this panel sat on any jury before for any cases? What was that case? Or was it criminal or civil?
It was.
Was it a while ago?
Yeah.
Okay, do you think that that case would have any bearing on your ability to be impartial in this one? Awesome.
And that's juror number 4?
Yes.
Okay, thank you.
And has anyone themselves been involved in any type of criminal suit or civil suit? Well, we covered the first topic, so that's pretty easy. The next topic is witness credibility. So we'll try and tie this together by asking how many, if any of you are parents. In juror number 6, how many kids do you have?
One.
One. In juror number 1, how many do you have? 3. Do any of your children fight at all, or did they?
Yes.
Have you ever had to decide between who was telling the truth in one of those instances?
Of course.
What type of factors did you look at to determine that situation?
Evidence. I saw exactly what happened or not.
So that's a great example. So we look at direct evidence, and you're going to be provided that in this case, and we're going to look up circumstantial evidence. You'll have to decide in this instance, potentially who's telling the truth and who's not, and it'll be your job to look at with your common sense and experience in life, or to gauge the evidence brought before you. So, for example, if you were to wake up on a cold snowy morning in December and you hadn't gone outside yet, but you saw footsteps walking towards your car. Juror number 3, what can you assume occurred?
That's the one with 10.
Exactly. So that would be circumstantial evidence. So even though you didn't see it, your common sense and reason can assume, okay, I didn't get up and I didn't go walk out to my car. So therefore, I can assume somebody else did. We don't know who it is. You didn't see it with your own eyes, but we're going to take that common sense and experience and be able to apply it to the case at hand as well here. Another question is, let's see, juror number 4. If I only put one witness on the stand, but you believe their testimony beyond a reasonable doubt, like through and through you believed it was true, would that be enough for you to reach a verdict?
Yes.
Does everybody else agree with that, or is there someone else on this panel that would need more evidence or feel that they would need more than just one person if you were to believe their story? You do?
Yeah.
What if, so, and George Flores will cover this as well, but it is up to you guys to determine what evidence you believe. You can believe all of a witness's testimony, you can believe part of it, or you can believe none of it at all. That's truly where your heart lies with that. It's my duty and Ms. Wilson's duty to be able to prove those facts beyond a reasonable doubt, and that's our burden today. With that, there is also no need to present more evidence than we need to. So does that change anyone's answer on whether they need more than one person, or would you be able to still take, if you believed everything beyond a reasonable doubt, and that's the burden we have to fill, would you guys be able to reach that verdict, or would you still feel comfortable doing so?
That was juror number 1.
Juror number 1, yes. Juror number 3, do you still feel unsure?
Yeah, I'm
No
sure.
worries. I want you guys to be truthful. That's my main purpose here. There's no wrong answers, like I said. Juror number 5. Would you view the testimony of law enforcement personnel as more or less or equally as credible as any other lay witness?
Say at least equal, maybe greater, just depends on, I guess, the circumstances of what they're testifying.
Is there anybody else who would view that testimony as more or less or equally credible? Anybody else? What would you?
Also agree,
That's
it's got to equal,
Equal or more, or equal in general?
probably equal. Just
Okay.
really depends on the situation. Probably more towards equal.
Okay, cool. That's good to hear. Is Judge Flores is going to provide a jury instruction that will say, if you do sit on this jury, that the testimony from a police officer is to be weighed equally with any other testimony that's provided. Do you guys feel confident that you could be able to apply that? Yes. And is there anyone here that's had an unpleasant experience with any law enforcement officers before? We've reached topic number 3. Like I said in the beginning of this, our goal is to be fair to all the parties involved. That's the one thing about the criminal system that is super important, is that we want to ensure that going into this, they have the most fair and impartial jury, because we want to ensure that if anybody was sitting there, you have the same respect back to you. You're gonna be asked to rely on your own common sense and everyday experiences to reach your verdict. So with that said, has anyone ever had an unpleasant experience with the court system?
No.
And does anyone here have any moral or philosophical belief that would make it difficult for you to sit in judgment of somebody else? Judge Flores is going to provide you with a list of laws that you are required to follow if you do end up sitting on the jury or one of the 7. If you were to disagree with any of those laws that he provides you, would you be unable to follow it because of your own personal disagreements with it? Now, as we discussed a little bit as well, the burden that we have to prove as the people or the state is beyond a reasonable doubt. So it's a high burden to prove, but it's also not merely an imaginary possible doubt. It's not anything that you could possibly think of what if situation. It's something that's reasonable. I know reasonable is this overarching concept of like, okay, what's reasonable? But that's why your common sense and experiences come into play here, because we all have a different grouping of experiences in life that have made us who we are. And you're to use those experiences to unbiasedly be able to judge the case. So you can't judge it based off of the way you feel about a certain group of people or the way you feel about a certain situation, but you can use what you know as a person to be able to take the facts and gauge whether or not someone's being truthful. So you can take situations in which you've had to do that in your everyday life to determine if someone's demeanor shows that they may be untruthful, or vice versa, that someone seems that they are being truthful. So for example, number 7, do you feel confident that you'd be able to identify a map of the United States without having any actual like labels on it? If you were to look at it, if I were to take away Florida, Maine, and Connecticut, do you still feel like you'd be able to identify that map?
Yes.
Does everybody else here feel that?
Yes.
They'd be able to do that? Is that because those couple states don't really change what you know to be true? So that's pretty much reasonable doubt. So it's something where you can still look at the full picture and grasp what is going on, but you don't need every little piece to be able to fill it in. Real life, we often don't have every small little situation. Well, I guess in this day and age, there's video cameras everywhere and phones, but in many instances, most crimes aren't fully caught on camera. And so you, as members of the jury, are going to have to decipher between sworn testimony, exhibits that are provided, and any other evidence admitted into this trial. And for the most part, you're going to have to piece together what really occurred. So do you all feel confident that you could do so impartially?
Yes.
The last 2 questions I have under that topic are more case related. Has anyone here ever experienced or had someone close to you experience any sort of destruction of property involving anyone you know or by a stranger?
Yes.
Yeah. Okay, let's see. I'll do juror number 4 first.
Leona break-in about 4 years ago.
And did law enforcement respond to that?
Yes.
Were they diligent about resolving it, or were you
Yes.
able to resolve it
Yes. I love we could know. Yeah.
as well as you could? Yes. Okay, good. And then juror number 6.
I've had my car broken into a couple times.
Oh no.
And me and my sister kind of destroyed somebody's TV one time. That was a long time.
Well, thank you for being honest. Do you feel that your car break-ins were handled appropriately by law enforcement, or do you?
I didn't call law enforcement.
Okay,
I mean, nothing was like broken, it's just the doors and then things.
do you feel that,
The doors were open and stuff.
do you feel that either of those experiences for either of you would, being in a case regarding that would have any weight on whether or not you could be fair and impartial in this case?
No.
All right. And the last question I have is that there are going to be members of, or witnesses and parties involved who are of different ages, races, things like that. If I were to put someone on the stand who was a teenager per se, would you be able to weigh their testimony as credibly as someone who is an adult? And there isn't, do any of you have any other sort of views on any type of groups that would affect your impartiality? No. Thank you, those are all my questions, Your Honor.
All right, thank you. Mr. Leibwadier.
Thank you, Your Honor. And thank you all for being here. In juror number one, I noticed you have some affiliation with the legal profession. What is your job exactly?
In a volunteer position, I help individuals who have felonies set aside their felonies.
I see. Okay. Thank you. Juror number four, what was the nature of the previous criminal case that you sat on a jury for? What was that about?
Domestic dispute.
Domestic
Yeah.
dispute. Okay. And that kind of brings me to my next question. You've heard a lot about reasonable doubt and judging people's testimony and so forth. I think you're probably starting to get the idea that these two people know each other, okay? So you are going to be asked to evaluate the evidence, which is going to include direct testimony from the witnesses. You're going to be asked to evaluate video testimony, evidence. And then you're going to be asked to make a decision. And that decision is going to be one of three things, really. You believe everything the prosecution says, and it's a guilty verdict. You believe everything the defense says, that's a not guilty verdict. But you really don't know what to believe. You think maybe it could be this, maybe it could be that. That's called reasonable doubt, okay? That's a not guilty verdict as well. How many people think, on a scale of 1 to 10, how strong does the prosecution's evidence have to be to meet a reasonable doubt verdict? Juror number four.
Well, maybe 5. I
Five,
guess, maybe.
okay, gotcha. Juror number 5, do you have an opinion on that?
I was gonna say maybe like a 6 or 7.
6 or 7, okay, so we're gonna talk a little bit about what the standards of evidence are. To me, 5, 6, or 7 sounds more like preponderance of the evidence. A little more likely than not that it probably happened. Clear and convincing evidence would be more like a 7 or 8. In my way of thinking of it, reasonable doubt is a 9 or a 10. It's the highest possible standard. Okay, so keep that in mind. Is there anybody who thinks that they would have any problem finding a not guilty verdict if the prosecutor hasn't met their burden? Is there anybody who thinks that they would have any problem returning a verdict of not guilty if the prosecutor has not met their verdict?
No.
Is there anybody who thinks that if my client, Brandy Hoover, doesn't testify, that she must be guilty?
No.
Thank you.
All right, we will start with challenges for cause. So Ms. Drizos, any challenges for cause?
Oh, Your Honor.
All right, challenges for cause, Mr. Lee.
No, Your Honor.
All right, preemptory challenges, Ms. Drizos.
Your Honor, the people move to strike juror number 3, Maggie Beisner.
All right, so juror number 3. We thank and excuse you for your appearance today. Usually we let you go, but you're gonna have to go in back and wait. But I do think that this gentleman, if you choose to, you can sit down or find a place to sit. All right. So let's replace juror number 3. And we'll replace juror number 3 with Philip Hammer. Hammer, you might have to walk over a few people. All right, Mr. Hammer, you have the opportunity to hear or see any of the questions that the lawyers asked the future panel. Is that a yes, sir?
Yes.
All right. Do you have any answers to any one of those questions?
That was any different from anybody else.
All right. You didn't find it. You didn't find anybody's answer to be different than your own in some way. All right. Ms. Drizos, do you have any questions for Mr. Hammer or to the rest of the panel?
I do, Your Honor.
All right.
Just one. Mr. Hammer, I see here you're a CAD operator. Can you kind of explain what that role
CAD, computer aided drafting, so I do like technical drawings for fabrication shop.
is? Okay, no further questions, Your Honor.
All right. Mr. Lee. Yes.
Mr. Hammond, have you ever been involved in any sort of criminal trial, either as a juror or participant? Have you ever had any property destroyed?
Not when it was mine. I had a car that later became mine. It was given to me by my dad. It was stolen and broken into. That was when it happened. So
I see, okay. I'm sorry you had to go through that. Do you think it's more likely or less likely that a police officer would be telling the truth than anybody else?
just as likely.
Just in general, just as likely? Okay, I see.
Perhaps slightly more, but
Right.
I guess that again, depending on everything else around, like all the different information.
And I gotta be honest with you, I think it's normal for most people to kind of trust police officers. Sometimes people really don't, so we have to figure that out. You're not gonna hear any direct evidentiary testimony from the police officer in this case. The police officer was not there when this event happened, okay? But we'll offer some testimony based on their investigation. I don't have any other questions.
All right. Thank you, Mr. Lee. I think preemptory challenge lies with the defense.
We would like to thank and excuse juror number 4.
All right. Juror number 4, thank you for your appearance today. That's Ms. Ramshaw, correct?
Yes.
All right. So Ms. Ramshaw, you can have a seat in the back and we will replace juror number 4 with Allison Diaz. All right, Mr. Diaz, you had the opportunity to see or hear any questions that was posed by the parties concerning this matter?
Yes.
Do you have any response to either of the questions that you previously heard?
No.
All right. Ms. Drizos, any questions concerning Mr. Diaz?
Mr. Diaz, just 2 quick questions. I see here that you're a firefighter and captain paramedic, is that correct?
Yes, ma'am.
How long have you been doing that for?
It'll be 25 years in April.
That's great. Congratulations.
I'm leaving. I'm retiring.
I believe it, I believe it. Do you believe that that career has, or will allow you to be impartial in this judging character? And then, do you feel that you would weigh the testimony of law enforcement as equally as any other witness? So no further questions. Thank you.
All right, thank you. Mr. Lee, questions of Mr. Diaz?
Hi, Mr. Diaz, thank you. You've been in firefighting, so you're used to the investigatory process, right? You think you can be fair and balanced today, listen to both sides and make a fair decision?
Thank you, Mr. Lee. I think we're at challenges for cause from Ms. Drizos.
No challenges for cause.
All right, Mr. Lee.
No challenges for cause.
All right. Preemptory challenges with the people, Ms. Drizos.
Your Honor, people think an excuse. Sorry. Allison Diaz.
All right, so the people thanking is choose juror number 4. And we'll replace juror number 4 with Teresa Agrusa. right, Mr. Grusa, we'll also have you muddle your way to the seats. And Mr. Grusa, you had the opportunity to see or hear all the questions that were asked of the potential voir dire?
Yes, sir.
All right, do you have any questions that stuck out in any way that you'd think either side should know?
No.
All right. I think we're at preemptory challenges, Mr. Lee.
Nothing for the defender.
But we have that I jumped the gun there a little bit. Ms. Drizos, would you like the opportunity to speak with Ms. Agrusa? Ask her some questions.
Yes, Your Honor.
Okay.
Mr. Crusoe, have you ever sat on a jury before?
No.
And have you ever been a victim or involved in a criminal civil case before?
No.
Do you feel like you should be fair and impartial in this instance? No further questions, Your Honor.
All right, and then Mr. Lee, do you have any questions, Mr. Agrusa?
I see you're in sales.
Yes.
Yeah, that's outstanding. I used to be in sales myself. What types of things do you sell?
I'm a local sales manager for a group of radio stations in Florida.
Fantastic. Okay. And so again, we're going to hear people of all ages. You probably interact with all types of people. Do you have any biases against anybody based on age, race, anything else? No further questions.
Thank you. Now let's go preemptory challenges. Any preemptory challenges, Mr. Lee?
None for the defense.
All right. So is the defense satisfied with this panel?
Yes.
As far as preemptory
Yes, we
challenges.
are.
Okay. Challenges for cause, Mr. Seuss.
No challenges for cause, Your Honor.
And Mr. Lee, you are satisfied with this
I am
panel?
satisfied with the jury.
All right. Preemptory challenges, Mr. Seuss.
No, Your Honor.
All right. Are the people satisfied with this panel?
Yes, Your Honor.
All right, thank you. All right, so we have our jury, and if you notice, we picked 7 of you. 6 of you will deliberate. Now, one of you will not deliberate. I'll explain that later, all right? But we have 7 jurors. Miss, I think the remaining jurors will go with Miss Susan, but Miss Neely, and to another courtroom. So that you'll have different questions asked of you, but you should be all set with this courtroom.
Thank you. Your Honor.
Thank you. We have 7 jurors, and I'm going to read you some instructions before we get started, okay? I think this would probably be a good time to take a break after the instructions. So we'll probably, because we picked the jury, we're going to give you, I think we give you an hour on your own for lunch. And then you get back, and then before you sit for the opening statements and testimony, what we're going to do is we're going to take that break as you come back, probably to get you paid. That's probably a good time to get you paid. So you have that in hand since we know our jury. And then so I would reconvene after I read you the second set of instructions. Reconvene in the jury room, and then Megan can take you to get paid. We'll come back out, and we'll probably start 1:45. Don't you think? At 1:45. That sounds all right. So let me read you your procedural instructions in this matter. Members of the jury, you've been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. So please stand. Raise your right hand if you're able. Each of you do solemnly swear affirm that in this action now before the court, you will justly decide the question submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court. So help you God.
I do.
Thank you. You will have a written copy of the instructions I'm going to read to you. You may refer to them during the trial, since no one can predict the course of a trial. These instructions may change at the end of the trial. At the close of the trial, I will provide you with a copy of my final instructions for your use during deliberations. So you're going to get a final jury. It'll be the 3rd packet of jury instructions to take in with you. We base that on the actual trial that comes out. All right. So things may change depending on what witnesses say, and you'll be instructed accordingly. Now I'll explain some of the legal principles you will need to know and the procedure we will follow in the case. The defendant is charged with crime of malicious destruction of personal property over $200, but less than $1,000. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the property belonged to someone else. Second, that the defendant destroyed or damaged that property. Third, that the defendant did that knowingly, that it was wrong and with the intent to damage or destroy the property. Fourth, that the extent of the damage was less than $200, but it was more than $200, but less than $1,000. The test for the value of property is a reasonable and fair market value of the property at the time and in the area of the receiving and concealing of stolen property. Fair market value is defined as the price the property would have sold for in the open market at the time and in the place if the following things were true. The owner wanted to sell but did not have to. The buyer wanted to buy but did not have to. The owner had a reasonable time to find a buyer, and the buyer knew what the property was worth and what it could be used for. There's also a less serious crime that's along with the instructions, and that'll be talked about at the final aspect of this case. It may be talked about, and that's the same instruction with a value of $200 or less. All right. You may also consider whether the defendant is guilty of the lesser serious crime of malicious destruction of personal property less than $200. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the property belonged to someone else. Second, the property destroyed was that the defendant destroyed or damaged that property. Third, the defendant did this knowing and that it was wrong and with the intent to damage or destroy the property. Fourth, that the extent of the damage was less than $200. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that she is guilty. Every crime is made up of parts called elements that you previously heard. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove her innocence or do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of each case. So this is the procedure that we'll go in for trial, all right? And some of you may have sat through this, some of you may have seen this on television. It's not as exciting as it is in television, okay? They cut out all the non-dramatic parts, but this is the procedure we're gonna follow. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyer, Mr. Lee, does not have to make an opening statement, but he may make an opening statement after the prosecutor makes her opening statement, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show exhibits like documents or objects. The defendant's lawyer has a right to cross-examine each of the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove her innocence or produce any evidence. If the defense calls any witnesses, the prosecutor has a right to cross-examine those witnesses. The prosecutor may also call the witnesses to contradict the testimony of the defense witnesses. That's called a rebuttal witness. And if we have that, I'll explain that to you. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, they are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as a judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies in each case. You must take the law as it is given to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts are in this case. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in the case is final. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on the witness's national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness or not, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to make an honest effort to tell the truth, or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge their testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, or suggestions or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does a witness's testimony seem when you think about all the other evidence in this case? When it's time for you to decide the case, you are allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witness are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully, clearly stated or explored. During the trial, you may think of an important question that would help you understand the facts in this case. You are allowed to ask any of those questions, all right? You should wait to ask questions until after a witness has finished testifying and both sides have finished their questions. If you still have an important question after this, do not ask it yourself. Raise your hand, write down the question. We give you a pen or pencil to take notes. Pass it to the court staff who will give it to me. Do not show your question to any other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by the members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. It's important that you see and hear everything that's presented by the witness. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyers and I will have a discussion out of the presence. And some things will be taken care of while you're in the jury room, all right? I may have to take care of other matters that have nothing to do with this case. We have another sentencing at 1:30, so I might be working on something else. Pay no attention to these interruptions. You're here for this case, all right? You must not discuss the case with anyone, including your family or friends. You may not even discuss it with other jurors until time comes for you to decide the case. During deliberation, you can discuss, but not previous to deliberation. When it's time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. I will also swear in the bailiff at the time. We'll take you to the jury room to deliberate. And that's probably the longest oath ever, all right? So it's like a full page, all right? So you'll know when you're supposed to talk to each other. You must talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of an improper conduct on any person's part. The restrictions I'm about to describe are meant to ensure that parties get a fair trial. In our judicial systems, it is crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it would be fair or incorrect or misleading information and might unfairly favor one side. The courtroom dynamic is set up so each witness is sworn in and then cross-examined. And that only applies to courtroom evidence, all right? So that's what you should make your opinion on their credibility based on. These restrictions start now and continue until I discharge you from jury service. It is your duty to decide this case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or read any information, including opinions or commentary about the case, whether in newspapers or television, the radio, the internet, or on social media platforms. You must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search like dictionaries, reference manuals, or newspapers or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene or any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider any evidence, any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media, websites, or in any other manner. If you discover, got ahead of myself, if you discover that a juror has violated my instructions, please report it to staff, okay? And that's Ms. Slavia. The court may take notes during the trial if you wish, but of course, you may take notes during the trial if you wish, and a pen and pencil and pad have been made available. You don't have to. That's completely up to you, all right? If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you do take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when your juror service concludes, your notes will be collected and destroyed. You can see we have chosen a jury of 7. After you've heard all the evidence and my instructions, we will draw lots to determine which one of you will be dismissed to form a jury of 6. It's a jury of 6, but 7 hear all the evidence. And we do that just in case somebody gets sick, is not able to finish, we have an alternate jury, okay? I think it's, so if you are dismissed from the jury, understand this might be your lucky day. You might want to go buy a lotto ticket, one of those aspects. You were not deliberating, but you've sat through the entire jury, okay? And you sat through all the testimony. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. I may give you more instructions during the trial. After the evidence has been presented, you will hear lawyers' closing arguments. Following the closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Take all together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important for you to keep an open mind and not to make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not fully be aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been based unintentionally influenced by someone else's stereotype. You must reach your own conclusions that they have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors during deliberation. You all have different backgrounds and perspectives, and therefore you should deliberate with the thought process of a learning attitude, and that's listening to everybody first and then coming to a conclusion by yourself based on your own personal belief, based on the evidence that's provided to you. So those are the procedural jury instructions. Any questions or concerns from the people?
No, Your Honor.
All right, from the defense?
No, thank you.
All right. What we're going to do now is I'm going to dismiss your presence. You have like an hour for lunch, okay? You get an hour for lunch. You should come back to the 6th floor and come see Miss Slaviak, and she will take you to the jury room, and then she will probably take you down to get paid before we get started. And we'll probably start a little after 1:30, depending on that sentencing, okay? So you've got, I'd say till about 1:10, 1:15 to make sure, and then to get paid. We'll provide that a little, because we probably won't get started till after 1:30, okay? Any other comment or concerning the court's instructions from the people?
No, Your Honor.
From the defense?
No, Your Honor.
All right, so we'll see you. Go to the courtroom, and Ms. Slaviak will dismiss you, and then you should come back probably an hour and 15 minutes, an hour and 10 minutes. Thank you. All rise for the jury. You can follow Ms. Slaviak. You can leave things in here. I should be in here if it's here, so it should be safe.
It's just a mug. So.
Okay, you should be fine.
Thank you.
All right.
You want me to take care of this now or before?
If they want to, anybody who stays and wants to take care of it now, let's get it done now.
And they just fill this out down there. I don't do anything.
I'm
You
not.
have to mark the whole day.
Yeah, you'll have to. They'll.
Can I see the form real quick?
Yeah.
I would get them. You're talking about payment. I would do it once they come back from lunch.
Oh, okay.
Yeah, definitely do it once. Now that we picked the 7.
I haven't seen anything. Yeah, I have to do a quick run through of our database, but he was questionably competent at the time, but it was so, yeah.
All right, so we're back on the record in 24-00734. We do have a sentencing at Mr. Ellis at 1:30. And that's a deferred sentencing, I believe.
That is correct.
So I think that's what you were that's what was being discussed. Anything to come to the court's attention, we'll probably adjourn to 1:30 for that sentencing from the people.
No, Your Honor.
All right, from the defense.
No, thank you, Your
All
Honor.
right, we're all set. We'll see everybody at 1:30. Take this off.